The unthinkable crumble, an overnight legal revolution. Picture this. You wake up tomorrow morning and a massive, century-old legal framework that controlled gun rights across the nation has suddenly vanished. It wasn't chipped away by political compromise. It was annihilated by a single powerful Supreme Court decision that few outside the legal world fully saw coming. This 6-3 ruling didn't just rattle the foundations. It sent a full-scale constitutional earthquake across America's legal landscape. The implications are so vast that even tenured law professors and constitutional attorneys are working overtime to grasp the full scope. This isn't some niche technicality affecting a few counties. This is a fundamental, nationwide redefinition of how our constitutional rights function. And it's already triggering an immediate, chaotic cascade of change. States are now in a frantic race to rewrite their statutes. Law enforcement is paralyzed by conflicting bureaucratic advice, and a multi-billion-dollar industry built on gatekeeping permits just watched its entire structure collapse. This pivotal moment has been building for years, and what just broke isn't just an old law. It's the entire philosophy dictating whether free Americans need a government permission slip to exercise their rights. The anatomy of tyranny, New York's impossible bar. The lawsuit that served as the battering ram against the old system was New York State Rifle and Pistol Association versus Bruen. It targeted New York's infamous proper cause requirement, a relic of anti-gun sentiment dating back to 1911. For decades, New York placed the burden of proof entirely on the citizen. To obtain a concealed carry permit, you were forced to prove you had an extraordinary special reason beyond ordinary self-defense. The bar was set deliberately high, essentially making it impossible. Simply wanting to protect yourself, your children, or your vulnerable family members was not enough. You had to document verified, active, individualized threats against you, show clear evidence of stalking, or prove your job placed you in unique, documented danger far exceeding that of a typical citizen. Even then, after submitting binders full of evidence, the final decision still came down to the purely subjective, arbitrary opinion of a single, often politically motivated, licensing bureaucrat deciding whether you deserved constitutional protection. This system was designed to deny rights, not protect them. The new judicial mandate: text, history, and tradition. In June 2022, the Supreme Court delivered the knockout blow, ruling that New York's scheme violated both the Second and 14th Amendments. The key to the ruling lies in the powerful new framework established by Justice Clarence Thomas. Any law restricting the Second Amendment must be consistent with the nation's historical text and tradition. This is the ultimate reversal of fortunes. Moving forward, courts cannot uphold gun laws based on modern policy arguments, public safety statistics, or what current politicians think sounds reasonable. For decades, gun cases were decided using interest-balancing tests, where judges simply weighed the citizen's right against the government's claim of safety, almost always resulting in the restriction being upheld. That era is dead. The legal tables have completely turned. The burden of proof now rests squarely on the government. To justify any modern gun regulation, prosecutors must produce clear, persuasive historical evidence that comparable restrictions existed during the founding era, late 18th and early 19th centuries. If government lawyers cannot provide these historical analogs from that specific period, the law instantly fails constitutional scrutiny and must be struck down. This is an extraordinarily high standard of proof, and most gun control measures simply cannot meet it. The domino effect, the end of the elite system. Bruen didn't just nullify New York's law, it instantly shattered nearly identical may-issue systems in 8 other major jurisdictions, including California, New Jersey, Maryland, Hawaii, and Washington, D.C. Before the ruling, these 9 areas collectively denied concealed carry permits to 60–70% of law-abiding, ordinary working citizens. Meanwhile, a favored elite, politically connected individuals, celebrities, wealthy business owners, and retired police, somehow sailed through the process with 0 issues. Bruen ended this 2-tier system where constitutional rights were explicitly dependent on your social status or political connections. Now, every one of these states is legally compelled to switch to a shall-issue model. This mandates that if a citizen meets objective legal requirements, like passing a background check and completing required training, the state must issue the permit without the subjective veto power of a licensing officer. The results are already staggering. In formerly hostile jurisdictions like Hawaii, where fewer than 200 civilian permits had ever been issued, approval rates have exploded from single digits to over 80% as thousands of new applications are processed. The bureaucratic warfare, malicious compliance. The opponents of the Second Amendment are not accepting this Supreme Court defeat. They are launching a coordinated counterattack of malicious compliance, a deliberate strategy to undermine the ruling by making it functionally impossible for citizens to comply. California immediately retaliated by layering on burdensome requirements, mandating 16 hours of expensive, hands-on training that, coupled with application fees, can cost the applicant upwards of $550. They have also intentionally stretched processing times from weeks to 6 months or longer, creating massive financial and time barriers designed to price out working-class citizens who cannot afford to miss multiple days of work for mandated training. New York struck back by passing emergency legislation that designates an absurdly broad list of sensitive places where carry is banned. This prohibited list is so comprehensive it makes the permit functionally worthless. It includes all public transit, subways, buses, parks, playgrounds, libraries, entertainment venues, houses of worship, and critically all private property unless the owner posts explicit signage permitting firearms, a sign virtually no one posts. New Jersey introduced highly invasive requirements for liability insurance, multiple character references, and mandatory disclosure of personal social media accounts stretching back years. This essentially weaponizes the permit application into a massive, intimidating background investigation designed specifically to discourage and frighten citizens from even applying. These actions are not good faith attempts to comply with a constitutional mandate. They are calculated, aggressive strategies of bureaucratic warfare aimed at nullifying the Bruen decision without directly violating it. The fight continues. Laws in the crosshairs and call to action, because of the strict, non-negotiable historical standard established by Bruen, dozens of existing gun control laws, which would have survived easily just a few years ago, are now facing critical constitutional challenges and are collapsing in federal courts. Magazine capacity limits, so-called assault weapon bans, based purely on cosmetic features, and mandatory waiting periods are all falling because the government cannot produce the requisite founding-era historical evidence to justify them. However, the war is far from over. Lower federal courts across the country are currently split on how broadly to interpret and apply the THT standard. Some judges are applying it broadly to strike down numerous laws, while others are applying it narrowly to preserve as many existing restrictions as possible, creating a confusing patchwork of rulings. The Supreme Court will eventually have to weigh in again to clarify the scope of Bruen in cases dealing with everything from gun prohibitions for nonviolent felons, purchasing age limits, and good moral character requirements. This ruling granted gun owners the biggest constitutional victory in decades, but the fight to preserve it is happening now, on the front lines of every state legislature and local county courthouse. Constitutional rights mean nothing if they are not known, used, and aggressively defended. Your voice matters. Join the conversation. What do you think is the most important gun law that needs to be struck down under the Bruen standard? Are you in a state where the permit process has finally become shall issue? Have you faced bureaucratic resistance when applying? Tell us your experience. Drop a comment below with your thoughts, your state's current situation, or a specific law you believe fails the text, history, and tradition test. Let's keep this conversation going and hold politicians accountable. Don't forget to like and subscribe for more legal analysis.